Right. Hello, everybody. Chuck Cook, Greg Siskin, Jesse Bless. Jesse's on mute because he is in a location where we probably don't want to hear it. No, it's not bad. It's kind of cool, but he'll join us when he speaks. He'll unmute himself. So it's great to be with everyone. I hope you had a great week. I had a great weekend, Greg. I mean, we harvested about 600 pounds of tomatoes and pulled off corn and peppers, and this is good. It's good. I'll be doing some canning this evening. So if the IRS is listening, I actually sold some of my produce to restaurants. So clearly an operating business, a hobby. First thing we want to talk about is the 601A litigation case, the IRE case. We, of course, have no news because we would have obviously shot her from the rooftops if we had anything at all. If I'm correct, the last thing was the government filed a notice that we are in the process of. Were you responding to it, Jesse? Or do we have to respond to it? I forget what it was. Where they say, Judge, it's another 11th, 9th Circuit's doing this case, and we don't know what's going on.
Right now they've moved. They haven't really filed a motion, but they're going to try to stay our case while the 9th Circuit decides whether to reverse a negative decision in Nevada. But they haven't put it on any file yet. And once they put it on file, we can make our response. But right now, unfortunately, when we filed our case, a lot of follow-on suits took place around the country, and
they started losing.
And I don't think it's no one's fault. It's just we have judges.
The government changed their tactics on these cases.
They're being. Well, I think the government is being persuasive in their attempt to say that you can't look at any delays whatsoever for however long, and it doesn't matter. And I think they're going to run into trouble. I think if we get the right panel in the 9th Circuit and the 4th Circuit, keep in mind too.
I agree. It's
I think it's worth noting. I mean, first of all, obviously, if you were the government, you would be making these arguments and you would be trying to persuade a judge that because you had some good decisions in other courts, that the court should be persuaded by those other decisions. So that's to be expected. But, judges are independent. I think just before this call, I sent you guys I think I sent it on our listserv about a case regarding a consular review of a marriage case where the DC Circuit had one decision, and then the 9th Circuit had a completely different decision on this issue, which was a really important issue, saying that a person had a constitutional right that was vested in an I-130 application filed by a U.S. citizen. Anyway, but I think the point is that the government's banking on the fact that this judge is going to be persuaded by other courts.
Greg, I just looked at that. So the 9th Circuit. They took a case. It's a woman whose husband went down for his interview in El Salvador, 601A case, right? And apparently he had tattoos. Yeah. And they denied him, saying he had gang tattoos, even though there was an expert that said there's no gang tattoos here. And I will tell you, this is the first case in U.S. history. Congrats to the team that won this case, in which a court of appeals has said that there is a legal right because of the right to marry. And it was the first thing they talked about. The right to marry was the first thing. And the second reason was due process toward the wife. So now I will tell you that there is a Supreme Court case that's kind of like this.
Kerry v. Dinn,
in which a spouse, the Supreme Court said a spouse didn't have a constitutional right. I think this was pled differently, and it was argued differently. And if this holds up, now the government is going to take the Supreme Court. There is 100% chance they're going to ask for cert at the Supreme Court in this case, because there's no way. Because what's going to happen if you live in the 9th Circuit, you're going to start suing the Department of State, and for any denial whatsoever. That's the floodgates will open. And
the pro-immigration administration that we're under is going to appeal this to the Supreme Court. Just kind of like keep that in mind as well. That it's about preserving power for federal agencies and not being pro-immigration.
So just know that we are on top of the 601 case. Now, last night I sent to each of our team, one of our class members sent us another list of case numbers filed in late 2022, which have been approved. So, Greg, I would ask your team to do their magic and run their report, and we can decide.
We'll do the same thing. And by the way, we have the last activity we had. It was on July 12th on our case. We had sort of a few approvals. We've seen a couple of expedite requests denied this week, but we're still not seeing much activity at all. We've had 17 approvals, no denials.
So that's disturbing. It's great news for the 17, and we probably need to dismiss them from the case. But for the other 100 and X people, it makes no sense when you see 2022 cases getting approved. Now, we did file. I wrote it. A great team that helped me revise it here at IMMPact, and we filed it with the court. Hey, Judge, what's going on, man? That was, I didn't say that, although maybe they'll write that again. Judge, what's going on? We don't understand. The rule of reason doesn't seem to apply here. So make a decision. The thing is, you can't say to the judge, dude, make a decision. You can't do that. So maybe he's writing a decision. Maybe it's going to be the decision of all time. It's the greatest decision he ever wrote. It's the capstone of his career. I don't know. But I think, our team will talk and see if we can't maybe submit another listing of cases. Judge, yes, they've approved 17 of ours. We're dismissing them. But by the way, they're also approving cases filed long after our clients, which makes
I think what it shows you is that the government's entire case falls apart if there's quote unquote jurisdiction, because they're not going to be able to defend the merits. And so they've won those two cases all on jurisdiction. But if they ever have to defend how they're processing these cases, they lose.
They can't.
Our case is based right now on jurisdiction, and the government seems to have a little bit of the upper hand on that issue. But I mean, for all we know, the judge is addressing those decisions to make up his own mind, and he has the ability to do that. It's just that every time a new decision comes out,
the government sends it to him. Hey, judge.
Exactly. And he has to address it, because what's going to happen. Even if we win, the government's going right to the Ninth Circuit. Yeah.
So, and I'm that Ninth Circuit, the Nevada case, that's actually kind of disturbing, because that one, the judge was an Obama appointee, and I read her decision, and honestly, I don't think she was awake that day. I'm really disturbed by that decision, and hopefully that team, that law firm that has filed 80 cases, individual cases, will work with because we're gonna do everything possible at AILA and IMMPact. We need good law, so we can't have random lawyers just writing briefs they've never written before, don't know the background, don't know the history, just writing. You're gonna lose. That's how you lose.
Again, I think judges actually, we started to see this more and more. The quote unquote favorable ones are favorable for this administration.
Right.
And so we're caught in a little bit of a pickle where you have people who don't want to criticize their friends and the Biden administration, who are doing great things to help all the immigrants. And so you have a little bit of that. If they come out and say, hey, why are you taking 5 years to make sure families stay reunited? They become an enemy to their friends and don't get appointed to the circuit courts. I don't know. It just seems like that's the environment. The best decisions we're getting are from Justice Gorsuch. Honestly, right? He's the only one who's holding or willing to hold federal agencies into account.
Right.
So that's
which I think he sees as his job as a judge. That's Marbury versus Madison. We get to decide.
That's exactly right. He's saying, he's trying to tell people, and this is going to come down when they're talking about deference. You always have to listen to what State Department says, and this is consular non-reviewability, what we just talked about. He's going to say, wait a minute, I can't look at this case. I can't decide what's reasonable and what's not. The APA gives me. Congress told me I could do that. And I don't even need them to tell me I can do it. I can do it anyway. So
Marbury versus Madison.
I think, and honestly, it's insane to me that we have such a feckless Congress, that now we're having judges who also don't want to be involved in the administration of justice. It's ridiculous. It's why they exist.
It's stunning to me. It's stunning to me. All right, so that's our 601A case. Let's take just a brief look at our 601 case. Aaron is our lead counsel on the 601 case. He's not with us today. I miss him. He's clearly the most handsome of all of us. So,
well, Aaron is he's not here because
he's in Peru. Isn't he in Peru? I think he's on vacation, if I'm not mistaken, right?
I'm not sure.
I think so. I think he's on vacation.
There's no
I
to
think
it.
he's actually hard at work at responding to the government's motion to dismiss, and
Well,
he's
and
going
yeah,
on
That's what he
vacation.
said that he's not leaving to Peru till Thursday, but he's
okay.
but
So-
he's working on that response of the opposition.
And so the government filed this. I think this is kind of funny. On June 3rd, they filed a final motion to dismiss. Final motion to dismiss. So I'm looking. Where's the initial motion to dismiss? Where's that? I think they clicked the wrong. When you have a drop down menu, I don't know how final gets in there, but it was filed June 30th. We have 21 days to answer, so that answer is due this Friday. So I suspect that we'll be seeing that here shortly, and we'll file that. I feel it's a tough district. We told everybody we're doing Nebraska. We're going right into the teeth of the dragon right there, and we've got a pretty good judge. They did, interestingly enough, after the government filed their motion to dismiss, the court sent out an order about consenting to a magistrate in this case. And I don't know, the magistrates are hit and miss. You don't know who you're going to get. But my concern, I don't know what your position on magistrates, Jesse, is. I think with a magistrate, if they rule against you or they rule against the government, you appeal to the judge. So you're just wasting, to me, you're just burning daylight at that point.
Yeah, I don't know. I see it both ways. I mean, if you wait for a district court judge, it's like indefinite. You don't want it. Some of the dockets are just so swamped, so they really push you to get magistrates involved. It's rare that a district court judge would overturn the magistrate, but it happens.
So here's what's interesting about this order, though. If the parties consent to final disposition of this case by the magistrate, let me know. So what they appear to be saying here is this is not going to go to the judge. The magistrate will make the final decision. That's how I read this. But we'll need to talk to, the government will let us know what their position is. Generally, the government has not, in my experience, agreed to a magistrate. So that's kind of where we are. The judge, the magistrate we have is Judge Cheryl Zwart. Good judge. I think she'd be fine on this case. We were initially assigned to a senior judge on this case. So it's kind of, I don't know who the actual judge is on this case since it was changed. And because all I could tell looking at the pacer here is that we have a magistrate assigned, but no judge assigned to the case. So maybe we'll just take the magistrate Zwart and move forward from there. So I guess the government says. Anyway, that's where we are on that case. And we are adding, by the way, we're adding new plaintiffs. So if you have a 601 case and pending for a year, hire us. We're going to be filing another set of cases. So go to the website, IMMPact LItigation, and we'll take care of that. Now, the next case that we need to talk about is our friends in EB5. No longer the IRE case, but the judge has not renamed it. Now, here is the deal in the IRE case. I am subject to a, what do they call it? Non-disclosure order. What did I sign, Greg, in this case? I forget. It was an order, a protective order. I'm assigned to a protective order. And under that protective order which is given by the court, I cannot disclose certain aspects of the discovery in this case. That's okay. I mean, it's what we're subject to. So what this means, and I want to take a look at this protective order here, which I apparently can talk about, is that let's see the protections of the case, designated material. So presumptively, the government has designated the discovery they have just given me under this protective order. Mass, indiscriminate, or routinized designations are prohibited. So I can't, say, hey, everybody, here's the discovery that I got. But I'm still waiting for the government which part of the materials qualify for this. I'll be calling the government later today, and we'll need to go through and decide which can and cannot be produced in this case. We have no testimony we're producing, so we're going to go from there. I'll be talking to the government, but I do want to let you know that I did get the discovery in this case. It is it's very interesting. In fact, let me just open it up right now and tell you that the documents provided to me as part of this is a listing, which is what the judge ordered, so no, just is not protected under protective order, listing of the number of unadjudicated 526s by country of the principal and the earliest priority date of each country's oldest 526. I do have that. The other second thing was the number of 526s received by quarter since 2018, and the number of 526s adjudicated by quarter since 2018, broken down by assigned country of birth for the principal applicant, including information regarding expedite grants. So I do have that information it's very simple in chart form. Some of this information is likely already public, but the charts they have prepared for me and discovery are not public, which obviously maybe they're afraid to have it disclosed. I don't know, but I can simply tell you that this is very useful to us in our pleadings. So I have a motion for summary judgment that is due. Let me just double check here. It is due on, find IRE here. Where's Mr. IRE? We are in the Northern District here. Come on. Case has been pending so long, I have to go back further in the listing here to find these case that's active. So bear with me. Where are Greg, I'm going blind. I can't find this here. This is in California. Where are we? There it is. All right, woo, found it. All right. So I'm getting old, man. I'm just getting old. And weird, the query button just went blank. Oh, there we go. Docket report in this case. And run that report. Greg, they charge you a penny a page whenever they run this report, a dime a page. They're diming you to death here. So the order from the court is my motion for summary judgment. The response is to the government's motion, and I'm going to file a cross motion, is due July 28th, so in 10 days. The government then reply is due on August 4th. And we have a hearing set in San Francisco, video conference, on August 21st. So there you go. The cross motion for summary judgment, the response to the government motion for summary judgment, that all going to get drafted. And we're going to have some fun with the oral argument in this case. But this information, I think, is very telling. And one of the things I will do in my motion for summary judgment, I'm going to say, Judge, you gave us this discovery. Here's why that's good, but here's why you now should allow more discovery and allow us to supplement the motion for summary judgment after we do some depositions in this case. So, Greg, there you go. That's the update on the IRE case.
All right, what do we have on our Ukrainian case?
Ukrainian case is, let's just pull it up in Pacer real quick. Where are we here? Ashtakov. Astakov is the name of the case. Pull up the Pacer and we'll tell everybody know what the Uniting for Ukraine Recovery of Fees case is doing. Government in this case, come on, docket report. You can make this happen here. Problem with this docket is it just takes a long time to list all the lawyers in the case. Run the report. All right, come on, wait for a response from server. And we served the government in that case. The return of service was the 27th of June in the case, the last one. So they have 60 days to respond. So they have till August 27th, even though it was filed on May 25th. apparently it took a lot of time for our colleagues to serve the government in this case.
Okay.
Just kind of looking through here. Service, court of place, which is misdocket. Okay. Yeah. So it looks like they have till August 27th, Greg, to respond to the complaint. No, I'm taking a step back. Answers due August 5th. So the service is complete, but they count it from the date of filing in June. Something happened. I wonder why the court picked that date. It's kind of an odd. Whatever. The answers due on the 5th of August.
Okay.
There we go. I can't wait to see the answer. It's gonna be fun.
Well, their whole history is basically dodging having to make any statements about this population. So this will be if they oppose it, it'll be the first time they've actually had to oppose something in the whole history of these two cases.
Yeah. So it'll be interesting to see what they do. We don't have to give the money back because so that's how the sentence starts. We don't have to give the money back because,
or we're in settlement negotiations with the plaintiffs. So they just don't know it yet.
Yeah. Oh, you may have forgotten to tell us that. So there we go. That's kind of what's going on. There is, so we are taking in cases for 601s to file as another group of 601s in the application. And we're considering some other litigation as well. You can go always to the IMMPact Litigation website for an update on your case. We have 28 comments today, and I bet they're all answering each other in this case. Oh, and finally,
I saw that at least one question was coming in about the data scraping.
Okay, before you get to that, just know we have nothing on Gomez, Acker, Go. There's nothing, and we don't know why, and that's it. Somebody asked me on a private message on Twitter, when will the court issue a decision? So I wrote back, August 13th. And he wrote to me, said, really? I said, no. I don't know. All right.
So I do want to say something, though, on the 601 and A's and the data scraping, because I've been kind of looking through this while we're there. And we have a lot of these cases have been renamed as far as their case, but they've kept the fiscal year and the name with the new service center numbers in there. The people that have got new numbers, it still reflects. We have most of the cases that have been approved were our 2019 fiscal year cases.
They're old. They're doing ours, the oldest cases.
Yeah, like. So they've gotten those. We actually have one RFE outstanding on a 2019 case. So hopefully that's going to be wrapped up soon. After that RFE, we won't have any fiscal year 2019 cases. We do have quite a few most of the 2020s haven't had any movement. There've been a few approvals for the 2020s. Otherwise, basically nothing. And I think if I had to sort of guess, it's sort of like on our cases, they are deliberately doing them in order of case number order, even though that's not what they're doing in practice for everybody else. So that's but that's my guess is as we see cases continue to get approved, it's going to be our older cases moving forward. So until the government really wants to negotiate and kind of wrap and get this case to go away, or we actually get a decision from the judge, my guess is that pattern will continue.
All right. Good morning, Daniel. Good to see you. Sky Limit asks a great question, and I wanted to answer this, even though it's not really part of what we're doing. Can you port an EB2 priority date to EB5? The answer is no, you cannot. Why? Because the porting of priority dates within a category was written to allow EB1 to EB2 to EB3, but EB4 and EB5 are not included in that regulation. So you cannot port a old priority date to EB5. Greg, do you disagree?
No, I agree.
Yeah, that's right. So mixed answers. You know why? Because it's the internet, and you can put anything on the internet, and it might be true.
Yeah, you definitely. I've looked at. I mean, a lot of people, especially Indian nationals, there's no way you can do that.
No.
And but it does raise an interesting point because we just saw an August bulletin come out that is absolutely catastrophic for so many people.
Yeah, I think that's a whole lot of Chicken Little, sky is falling. as it relates to most of us. But as you know, I wrote a blog on this 2 months ago and said the coming catastrophe. The EB1s are going to become current again for almost everybody. I mean, this is just, we ran out. It's actually not a bad thing because this means that they used all the numbers.
Why don't they move it to unavailable?
That's what I don't get. Why just put you? Just
They
put
used to
you.
do that, and we haven't seen a U in a bunch of years.
That's what they used to do. So it makes no sense. Maybe that's just the new
scares
person.
people into thinking that there's now like a 10 or 12 year wait when in fact the dates are, you know,
there's not a 10 or 12 year wait.
But they also should, I mean, if they have these numbers on a quarterly basis or even monthly, why not just be transparent and say how many are left?
You know, oddly enough, I just FOIA'd that information.
Really?
I did. I just FOIA'd it to USCIS because, Department of State does the visa bulletin, but they don't get the numbers themselves. Those numbers come from USCIS. Both these pending, you know, how many haven't been adjudicated, which we know generally, but if you go to the stat page of USCIS, it'll say pending I-140s, 200,000. Which ones? Which there's 5 different types, you know, which I-140. I FOIA'd that specific information if you want to be 2B3.
I mean, I think Jesse raised a good question. What would be the reason why they couldn't just have a running tally of how many numbers are left in each category?
There's not. I mean, why is there like a doomsday clock?
Yeah, I mean, I guess that in theory, numbers could come back into a category during the year, and that the number might be subject to, you know, it may be sort of a changing number from time to time. But it seems like they could do that, and that would be probably make people, you know, a lot more. I mean, make them a lot easier for people to plan.
Well, this is a similar issue to the H-1B lottery problem.
Yeah.
You know, I got the discovery that I asked for. Well, at least I've got the discovery.
Did you get what you asked for? Or did you get what they gave you?
No. I got what I got the stuff I asked for. And it's quite clear that there is a counting problem at the USCIS. Apparently, 1 + 1 does not equal 2 when you work for the USCIS, and caps don't appear to mean what you think they mean in the caps. And that's apparently true throughout the agency.
So they undercounting or overcounting?
I'm not going to say.
Okay.
But the information will be released eventually. Maybe in litigation, we shall see. Let's see. We've got a lot of questions here. Good. It said, Charles, do you think after all this time that our judge would have already made the determination? Well, it's been pending, what, 2 months, 2.5 months, the motion to dismiss? Has it been that long, Jesse? Is it unusual? It's getting towards unusual. It's not crazy late.
I don't think. I mean, it's a class action too, so there's that motion with it. The other thing is there's 2 negative decisions that have come out that have complicated that. Plus, there's been a transfer of the judge. Judges now. There's also cases in the district that the judge was unaware of. We were unaware of that. He's got to deal with that. How do you treat? So there's a lot going on. And there's also in the back of the judge's mind, he may be hoping that the agency takes action on the cases and he doesn't have to make a ruling. I mean, I don't know.
Jesse, let me ask you this question. I didn't clerk for a federal judge. Did you clerk for a federal judge?
No, I did not.
When did they start working?
Yeah, August, September, right? Yeah.
So they're running, the clerk's kind of on the downline that's working for the judge, and maybe they're waiting. I mean, I don't know, but it's out there.
I think it's it's a good thing that he's not ruling, honestly, at this point, because right now, the government has pulled some punches with some other judges, and hopefully he's making his own independent evaluation based on our arguments and not.
We gave him, and we were able to insert.
Yeah.
They took out my snark. I appreciate my colleagues removing the snarky part of my submission. That was probably important to do. But nonetheless, we get our point. So do we have receipt number 601s No, we don't have that. Nobody has given us any 601s out of order that I'm aware of.
Just a
Brittany, will Judge Zilli make a ruling on the 3 as all at the same time? My guess, now we know who the lawyers are on that kind, and Those cases have not been made part of our case. In fact, those parties objected to being in our case. So he may make them at the same time or he may not. Greg, can you tell us the years you're ready to do? It's 2019 and the recent approvals for us. The judge, there is no limit on a time frame for a judge to make a decision. Unlike the USCIS argument that they have no limit, which is not true, the judges, they're under an ethical obligation to render justice swiftly and fairly. That's their obligation. The same as the one case is pending. Well, Carly, again, if you've got evidence that newer cases are adjudicated, get that to Aaron and I and Jesse and Greg, and we will move forward with it. All right. Let's see. Carly, I have a significant number of small cases being adjudicated in order. I provided them your office, but I've lost. Carly, give me all of them. Don't just give me some. Give me 50, 100. Because if the Heart Service Center is actually working, which they supposedly are, what are they doing if they're not doing our cases, which are some of the oldest ones out there? Of note, the government said our precedent was 25 months. Finally, our precedent time was 11 months. Yes. Yeah. That we do know. Let's see. Do those of you have copies of all the final responses I have not received? Carly is like on top. Maybe does Carly need a job as a paralegal? Because she could help us here. Chuck, do you think it's positive that we only have a magistrate in a 601 case? I think that's fine. Judge Ward, she's a good judge. I did a little bit of background on her. I think she'd be fair in this case. I don't think she's political really in any way. So the thing with magistrates is that they're not appointed by the president. Magistrates are hired by the local district court judges, and they come from the community that they live in. So that's not a bad thing to have a magistrate in this case, since we don't have a judge. So I think we're okay. How many plaintiffs in the case still? Well, if we had like 200 and we had 17 approved, Greg, so do the math. Why wasn't an approved on further concern to get an EAD? I don't follow that question. I don't follow.
I think they're saying that why
doesn't USCIS talk to each other? That's the question.
Yeah.
That's actually, I've done this for 35 years. Greg, you got about 33 years. Jesse, you've got like 5 years. No, just kidding. Jesse's got 20 years. So, we have almost 100 years of collective experience, and we want to know the answer to that question. Why is this information even hidden? You're not releasing privacy. There's no Privacy Act concerns. That's why I filed the FOIA. I want the numbers. TRAC does this for court cases. They filed so many FOIAs, they basically entered into agreement with TRAC, with the EOIR, the courts, immigration courts. They get the data basically the same time it's posted, and TRAC and EOIR post tons of information about their cases.
Chuck, this AI tool that I'm working on, this legal research product, I'm trying to get in there, in addition to all the other stuff that you would expect in there, FOIA responses for a lot of these cases, but that USCIS makes a couple of FOIA responses available online, but there's a lot of that stuff out there. But my guess is that once these FOIA responses come in, it's sort of like, they oftentimes they get buried, or they're useful for the person that FOIA'd them, and they don't really get into the ether. But
like the FOIA, the discovery we just got in the EB5 case, there's nothing in there that couldn't be posted publicly. There's no secret information in there. It's going to make the government look bad. Okay, well, okay. Yeah.
But I'm trying to get that kind of stuff in there, because I feel like that's a lot of times the only time we get actual real information versus the hidden information that versus what we see online a lot of times, which is not very specific or helpful.
All right, we've answered all our questions today. I think we've talked well and good. Next week we'll be back on Tuesday at noon. Jesse will not be at the car dealership, I don't think, next week.
I will be on a bike.
Oh, that's right. You got the ride across Iowa. What is it, Rick Rack or something like that?
Ride, yeah. 500 miles. I will have a sore rear end, and I will not have much internet. So
you know what I would love, Greg? If you had your AirPods on and you put the camera right on the handlebars.
Oh yeah.
And you could talk to us while you're pumping down about 40 miles an hour, going down the mountain in Iowa. Just kind of So it's just flat, right? It's basically flat.
Iowa, no, that is a myth. I don't know who spread that, but that is an up and down state. The whole state is full
Well,
of
it's
hills.
the great prairies. It's great to see you, Greg. Have a great ride
All right,
next week. We'll see everybody then. Bye-bye.